I'm going to put this mic right here and see how it picks up. And Steve, if you can figure out how to minimize this sidebar. I'm going to get started with my segue story that I came up with last week when Steve finished talking about this bizarre little statute in Title 18, 925, that gives ATF this magical ability to restore your rights to possess a firearm because you had lost that right due to a federal conviction. And it's not based in any precedent other than when the Gun Control Act of 1968 was written between 1963 and 1968, there was parties at the table that were trying to get their interests inserted. And one of those parties was the firearms manufacturers. And when they saw the number of people that might become prohibited from possessing firearms when the Gun Control Act passed, they were trying to insert a little bit of protection in there. One of them was this magical ability not to pardon you from your federal conviction, but to give ATF the ability to say that based on a restoration of your rights, a restoration of rights investigation conducted solely by ATF, we wave a magic wand, say you're an upstanding citizen other than this insignificant prior federal felony conviction. We're going to give you back your right to possess firearms. Not your whole civil rights, not your right to vote, just the right to possess firearms. So when you think about it in that historical context, it's a bizarre thing that we had the ability to do. But I've been with ATF long enough to remember doing restoration of rights investigations. And ironically, that little bill line item prohibition did not convey to the restoration of rights to possess explosives. So if you're a licensed blaster or fireworks shooter and you have an old federal felony conviction, we can still do a restoration of rights investigation. I got to do one in North Charleston about 5 or 6 years ago. When the Safe Explosives Act got passed after 9/11, and possessors of explosives had to have a license to do certain things and do certain storage and transport, there was a guy that worked out of North Charleston as a professional fireworks shooter for Zambelli Corporation. And he couldn't get his license because he had a conviction, a federal conviction, for stealing scrap metal from the Charleston Naval Shipyard. So he found out through Zambelli corporate counsel that we could restore his right to be an explosives possessor through this avenue, and we were able to do that. So that's how obscure and weird that statute is, and that's just a segue to more obscure, weird stuff and why there's an ATF agent here to speak to you. I was here last year. I'm sure a lot of you were here last year, so I won't get into the introductions, but I've been an ATF agent for 25 years in South Carolina, and I kind of have a feeling for the things that people do not understand about ATF and do not understand about the federal firearms laws, and I'm going to answer as many questions as we can fit in, but to give me a framework to work out of and to fulfill Steve's desire to do an update of things that happened last year with ATF and the federal firearms laws, I'm going to start with what did the President say on January 5th, or whatever date it was. Because that weekend prior to that Tuesday speech about his executive orders, like on Saturday and then on the Sunday morning talk shows, I was hearing every Republican candidate say, whatever he says on Tuesday, I'm going to repeal it my first day in office. And he hadn't even said what he was going to say yet, but they were going to repeal it or repeal it. So then the other day I get at the House a reminder that people take these things and run to extremes with them. This is my official Republican Party survey, which tells you I'm a registered Republican, but this is from the Republican National Committee, and I'm supposed to answer these questions. And number 5 is, do you believe President Obama's use of executive orders to circumvent the legislative process in order to change, cancel, or create federal law has been damaging to our constitutional democracy? Makes it sound pretty frickin' dangerous. Whatever it was he said that day must be pretty dangerous because it's jeopardizing our democracy. So I thought I would go through it and show you what he said and what he didn't say and how really he didn't say anything based on law. Because there's people in the White House that are smart enough to know that they can't change law. They can't amend the Gun Control Act by themselves. So they just kind of talk about it, but they left out a lot of words. So this is in your handouts. It's in your material. I don't need to read the preamble because what I caught myself doing in North Charleston last Friday was reading material that you already have. So I'm going to try not to do that. I want to get down to the bullet points so I don't become redundant. Okay, there's the law. because what they also did was they made me mad because they muddied the waters on several subjects. And what working off of this framework does for me is there's 1,000 other teaching points in here for us to talk about as it relates to federal firearms laws, and I'll stumble onto them as I see them. But right now we're at the part where it says clarify that it doesn't matter where you conduct your business, from a store, at gun shows, or over the internet. If you're in the business of selling firearms, you must get a license and conduct background checks. They're trying to, I don't know, come out strong and tell you that if you're dealing in firearms without a license, by golly, you better get a license. So what are they talking about? What is dealing in firearms? What is engaged in the business of firearms? Well, there's definitions in the gun control. I can tell us exactly what it is, and I will get down to them in a minute. But there was something else I forgot to say in North Charleston on Friday, was that when you are a licensed dealer, a federal firearms licensee, how many FFLs are in the room? No FFLs here. Okay, a federal firearms licensee is somebody who is licensed by ATF under the 1968 GCA to be engaged in the business of buying and selling firearms. When you're licensed, you have access to the distribution of firearms in commerce in the regular course of business, which means new guns. You can get new guns from a wholesaler. If you're not licensed, you can't get new guns from a wholesaler or manufacturer, wholesale, retailer. It's a normal commercial distribution process that relates to the federal firearms industry. So if you have a federal firearms license, you can sell new firearms. A lot of this unlicensed dealing they talk about is only related to used guns or guns from a personal collection. So that's part of something I wanted to clarify up front for you, those of you that aren't familiar with the firearms business. I'll read some more, a little bit more. A person can be engaged in the business of dealing in firearms regardless of the location in which the firearms transactions are conducted. For example, a person can be engaged in business dealing firearms even though the person only conducts firearms transactions at a gun show or through the internet. This is language that talks about, engaged in dealing with firearms, but it leaves out a lot of words. So what I want to do is just go right down to where the actual definitions are. In 921, as applied to a dealer in firearms, as defined in Section 921A11A, a person who devotes time, attention, and labor to dealing in firearms as a regular course of trade or business with the principal objective of livelihood and profit through the repetitive purchase and resale of firearms. Here's the important part. But such term shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal firearms collection. That is your Second Amendment protection listed in the Gun Control Act that gives you the right to sell firearms from a personal collection or add firearms to your personal collection, and none of that has changed. All they did was leave those words out. If you are an individual, which is the term we use that's given to us in the Gun Control Act as opposed to a licensee, if you're an individual and you have a personal collection of firearms, limitless number, you can have as many firearms as you want. If you want to sell 2 or 4 or 6 or 10 firearms from your personal collection, and you want to do it through an advertisement in a newspaper, the old-fashioned way, where someone reads the classifieds in the Charleston Post and Courier and calls you on your house phone and says, I'd like to buy 2 of your guns that you advertised. And you say, come to my house and I will sell them to you. You go to the person comes to your house and you sell them 2 firearms. That is protected 100% all day long. It hasn't changed. You don't have to know anything about your purchaser. You don't have to do any paperwork. And there's no such thing as gun registration in the state of South Carolina. There's nothing you have to do, and that has not changed. What this extends to for personal collection and hobby is also, if you have a personal collection of firearms and you want to dispose of them at a gun show, you are allowed to do that. You can go to a gun show and you can register with the promoter and you can pay $25 to buy a table. And you can sit down at that table with your personal collection of firearms, and you can sell them to anyone. And you don't have to do anything. And that has not changed. Correct. And here's the enforcement side of some of this. If you violate any other thing in the Gun Control Act, like selling to someone from out of state or selling to someone who's otherwise prohibited, how do I prove that you have knowledge of the federal firearms laws, that it's a knowing violation? It's almost impossible for us to prove an individual citizen is knowingly violating these things unless we do some other things to prove it. So ATF cannot go out and just randomly try to hold people accountable for their knowledge of the federal firearms laws. There's other steps that we have to take. As an individual, you have no burden of knowledge of the federal firearms laws. If you know the law, you've burdened yourself. If you are somewhat aware of the laws and you know that you can't transfer a handgun to a resident of another state, then you should not. And we could potentially hold you accountable for that. Well, the reason this is, I'm really getting to the point. I'm not beating around the bush. I'm telling you what you want to know about what the president said. And that's because most of you have a personal firearms collection. You want to know if any of your rights related to that have been infringed upon, and they have not. You can still buy and sell guns from a personal collection. And the beauty of this law, I'll get to later, is that it can work both ways for all of us. Both your Second Amendment rights and my ability to prosecute somebody. Now, there's an additional, more definitive definition down here a couple paragraphs later. The term, with principal, objective, livelihood, and profit, means the intent underlying the sale or disposition of firearms is predominantly one of obtaining a livelihood or pecuniary gain, as opposed to other intents such as improving or liquidating a personal firearms collection, provided that proof of profit shall not be required as to a person who engages in the regular and repetitive purchase of or disposition of firearms for criminal purposes or terrorism. For purposes of this paragraph, the term terrorism include activity directed against the United States persons which blah, blah, blah. So what they did right there is they gave you protection and they gave me enforcement powers because of criminal intent. They laid that out in language right here. We don't have to go anywhere else in federal rules or law to look for criminal intent. So how do we utilize that? I'll get to it later. I'll show you a case about that. So there's your definitions of what they left out up here. Now what they'd like to do, or what their intent was by coming out with this language or this statement, was to try to force more people that are on the fringes of dealing without a license into compliance. And those are the people that, unfortunately, game the system with the repetitive buying and selling of firearms. And I told you can't get access to the new firearms distribution chain without a license. But people that aren't FFLs and choose not to go through the hassle of getting an FFL, what they do to make money on guns and be excited about their hobby and finance their hobby is they go buy guns new on paper from a dealer, and then they turn around and resell them. And a lot of them do this because they like guns, they like talking about guns, and they like making $25 or $50 on a gun. So they'll find the best deal they can find on GunBroker or Arms List. They'll order some guns. They'll go to their local FFL and pick them up. They'll buy 5, 10, 15 handguns at a time, brand new handguns. Then they will go to the flea market, Anderson Jockey Lock, the Ladson Fairgrounds, and they will set up a table and they will sell these firearms at a profit to people off paper who might otherwise be prohibited. That's the little gap that we're trying to address, not we, this wasn't me, this wasn't ATF, this was the White House, They would like to tighten that up and try to get more of those people scared into either getting a federal firearms license or stop flipping guns. And it doesn't just happen to have to happen at a flea market or a gun show, because gun shows are run by gun show organizers, and most of the people there selling have FFLs. And they're keeping records, and they're doing Brady background checks on every gun sale. It's the non-licensees that aren't doing Brady background checks, and that's what they would like to address. So this happens on the internet all day, every day, because there aren't ATF agents at the FedEx distribution center in Memphis or at the UPS distribution center at the Columbia Airport shaking boxes to see if there's a gun in it. So there's guns flying all over the country right now that are being bought and sold over the internet and through email contacts, and we don't know about it. We don't know it until it comes up, it gets recovered in a crime, and it gets traced through ATF in a normal trace manner, and we find out that it traces back to a guy that has, 100 multiple handgun sales reported, in the past 2 years, and he's obviously a gun flipper. He's somebody that is buying and selling a large number of guns and should have a federal firearms license, because every gun that he buys and sells doesn't have a Brady background check attached to it. If you want me to stop and define anything I just said, I will. If you want to know, Brady background checks, tracing, I might get to it later, but I'm going to get through the speech first. Yes, sir. There are. You cannot, an individual. Right. The risky side of gun broker and arms list is if a seller and a buyer agree to go offline together. If they can wink and nod to each other through email, they may sidestep licensing, and there's a potential for the seller to directly ship the firearm to the purchaser. And there's no way we'll know that's going on. The normal lawful way to do it on gun broker is a seller puts up a gun, everybody bids on it, the winning bidder gets notified by the seller, hey, you won the bid, I'm going to ship, what FFL do you want me to ship your gun to? And he goes to his FFL on the shipping end, he ships it to the winning purchaser's FFL on his end. The winning purchaser goes to his local FFL, he pays a $25 transfer fee or whatever the FFL wants to handle that, and he fills out an ATF form 4473, and the dealer calls FBI NICS for a background check, and then he receives the firearm. And that's a lawful handgun purchase that happens, or any gun purchase that happens all day, every day. It's become a major driver in the industry. That's how a lot of guns are bought and sold, because it's a way for people to go outside of their local retailer. Like if you go to an Academy Sports and you say, I think your price on that Glock 27 is too high, I'm going to go home and shop around for a better deal. And you find a better deal, and they ship it to your local friendly FFL who lives down the street from you, and you go there and you pick it up, and you save $50 on what Academy was going to charge you for it. That's what drives all that business. And that's all legal because everybody's getting a Brady background check. It's the ones that are going outside of those parameters that worry us, because they could be shipping to felons or they could be shipping to gang members, and nobody really knows how much of that is going on. But this is what this was trying to bluff the public into. Maybe I shouldn't sell firearms without a license. And getting an FFL is not hard. Anybody can have a federal firearms license. The only thing that gets people sometimes is these unforeseen things that come up, local zoning. If you have to get a business license at the location where you want to have your FFL, it could be a problem, because some jurisdictions will not allow you to run a commercial license from your residence, but some jurisdictions do. Most jurisdictions in South Carolina, most counties, if you live in an unincorporated area of a county, you can get a federal firearms license at your house. And the UPS truck can come and go from your house all day, and you're in the gun business. You get deliveries from a wholesaler, and you ship your guns out to your purchasers. And that's very common. Horry County doesn't like you doing a business from your house, and they probably won't approve of you getting a federal firearms license. And it drives some people to tears. Horry County wants you being in a storefront, in a commercial area, and then they'll sign off on your federal firearms license. Yes, sir. This is why I don't need a fancy PowerPoint, because questions drive my hour and 15 minutes every year. He wants to know what rights he's going to give up if he becomes licensed by ATF. You know, how many times are the jackbooted American terrorist thugs going to come kick your door down and search your house? The answer to the question is, we are entitled to 1 inspection per year. And we have to call you and schedule it during your licensed business hours. So when you fill out your application for a federal firearms license, they ask you, they have a block. It's got 7 days in it, and you write down your hours you're going to be open on those 7 days. It could be 6 p.m. to 7 p.m. if you're a household dealer. And that's when in industry operations investigators, the regulatory side of ATF, that's when they can come inspect your records. And they can only do it once a year. In the reality, most FFLs get inspected maybe every 5 years. The number of FFLs in the United States peaked at about 230,000 many years ago. And then when we started to enforce this zoning application, where we were actually going to not violate local zoning law, we were going to check with local zoning to make sure you could have a license, the number of licensees dropped down to about 110,000. But since the internet sales have gotten popular and everybody wants to save money on their guns, it started to go up again. So maybe it's 175,000 licensees to be inspected by about 1,000 ATF inspectors. So you can just do the numbers yourself. Yes, sir, Mr. Attorney, whose name I don't know. I think really, I don't know the specific answer to that. That's probably in the CFR somewhere. Like a nuclear thing? Oh, let me say this about inspections is, huh? He can self-inspect, and he should self-inspect if he wants to keep his license. Now, most of the inspection assignments that are assigned to the investigators on the regulatory side are for high-volume dealers, and their real inspection criteria relates to non-responsiveness to the ATF tracing center. If the tracing center is requesting a trace be completed by this retail FFL and they're not getting back to the tracing center, or they have a high volume of traces with short time to crime, those are things that target a licensed dealer for inspection. Otherwise, you could go many, many, many years and never be inspected. But if we ask you to be inspected and you say, no, you can't come inspect me, then immediately they can go to their revocation proceedings. The worst thing that can happen to an FFL is that we revoke his license. No.
If we're an FFL, if I'm an FFL, does that override state law?
No. No. I'm speaking into my microphone. There is almost no federal law that pertains to carry. I never talk about carry because your South Carolina law experts are going to tell you about carry. There's only one federal firearm law that talks about carry, and it's the Gun Owners Protection Act of 1986 that says if you want to go bear hunting in the state of Maine, the New Jersey state troopers can't seize your rifle from your trunk of your car, in a nutshell. There is no other discussion in federal firearms laws about how you carry, whether it's CWP, open carry, whatever state, doesn't matter. We don't speak to that. We only speak to how you conduct your federal firearms license, your acquisition and disposition book, your records, your 4473s, your compliance with Brady background checks on NICS. That's all that has to do. How you carry your handgun outside of your house is outside of our purview. Your greatest insulation is a consignment sale through an FFL or an outright sale to an FFL. Every city has an old, reputable gun store that does things for their customers in an old-fashioned brick-and-mortar way. In Charleston, it happens to be Carolina Rod and Gun. One of their specialties is consignment sales. If you have an estate situation, granddaddy passes away, granddaddy's got 30 firearms, family doesn't want to deal with the disposition of those, you consign them over to an FFL, He takes care of all the dirty work. He checks every buyer. He gets the best price he can for you, and you guys work out the finances of it. So that's the easiest way to make sure that you're not having to deal with shady people coming to your house or have to do anything like that. So just contact an FFL about outright selling them the guns and let them figure it out, or doing a consignment situation.
How do you safely buy a used gun from anyone other than FFL?
As the buyer, if you would really like to do a purchase through an FFL, you can tell the seller, I want this to go through an FFL. I would like you to take your firearm and sell it to the dealer so that I can buy it through the dealer. The dealer will log it in, do a Brady background check on you as the purchaser, and then sell it to you and take a cut, put $25 on top of it. As the buyer, the only fly in that ointment is what you're really trying to do as a buyer is make sure you're not buying a stolen firearm. And that's not a perfect situation, because you would think that FFLs have the ability to check every incoming used firearm for stolen, and they really don't. It's something internally with ATF I think is a big problem. I, years ago, thought that maybe we should have a 1-800 number for licensees to call and do checks on guns through NCIC to see if they're reported stolen, but I really didn't want to champion the program and get drafted into headquarters to run it, so I never really got into it. But that's a slightly imperfect system. Pawn shops, there's a pawn slip system. Those guns get checked by local law enforcement for being stolen. But regular FFLs really don't have a way to check a gun for stolen. It's not good.
My truck got broken into a couple years ago on a hunting trip, had 2 Browning rifles stolen. A lot of the gun manufacturers like Browning have a program, if you call and report, give them their serial number, they'll put it in their system. If it ever comes up for some reason, somebody, for any reason.
The only way it would come up with Browning is if somebody tried to send it in for repair.
Or part. One of my guys
Or part.
involved in it when they stole it. So.
Yeah, that's nice of Browning to offer that service, but unfortunately, while we're talking about stolen guns, very briefly, while I have an audience, is any of you that own firearms, please go home tonight and write down the make, model, and serial number of everything you own, because ATF does not know what guns you own. We can't help you if your gun collection gets stolen, and you can't report it to the sheriff's office to put it in NCIC as a stolen gun because you don't have the information written down. It's hopeless. There is no such thing as federal gun registration. ATF does not know what guns you own, does not know what guns you're actively buying. So you can't call ATF and can you tell me my serial number of my guns? The answer is no. So please spread that word amongst everybody in the gun community. If you don't write down your make, model, and serial number and caliber, we can't help you. Pictures, yeah. Yes, sir. Outside of law enforcement, and some of you guys do criminal defense, a lot of you don't. So if I say something like NCIC, you don't necessarily know what I mean. It's the National Computerized Information, National Criminal Information something. It's the computer system that every law enforcement agency uses to share information about stolen property, criminal histories, and a whole bunch of other stuff. So a law enforcement agency can run a gun serial number to see if it's been reported stolen, but nobody else can. But ATF's a law enforcement agency. So like I said, we should be running used guns for FFLs, but we don't do that. But you as a citizen, there's really no way for you to check to see if a gun has been reported stolen. If you call a local sheriff's office and say, hey, I'm thinking of buying this gun, can you run it and see if it's stolen? They're not going to do that. They're not going to help you. They're not set up to do that. So unfortunately, that's a bad part of the system right now. It could get better. No. FFLs are allowed to have a personal collection that's separate from their inventory. In fact, some of them choose to acquire firearms on their license and then transfer it to their personal collection. And what the inspectors tell them is that you have to leave that gun in your personal collection for a year before you can sell it again to ensure that it is part of your personal collection. So, yeah, if you already have an inventory, you want to have a FFL inventory and a personal inventory, yes, you can. All right, I'm going to go back to this to see some of the other teaching points that I was thinking about and some of the things that muddied the waters. Ensure states providing records on background checks for okay. Make the background check system more effective and efficient. Bottom line, there's so many gun purchases going on in the United States that the NICS part of that National Instant Check System run by the FBI has been like working overtime for the past couple of years trying to keep up with these NICS checks. And they are underfunded, so the president is directing more money to go to FBI, to hire more people, to do more background checks, just to try to take care of you, the gun-buying public, to make sure these things are done in a timely manner and done accurately. There's also language in here about trying to give the states more money to modernize their criminal records, because all 50 states keep criminal history records differently from each other, and the FBI tried to unify it and unify the reporting of it starting when computers started, in the 70s and 80s and 90s, but they're still not completely there yet. So if FBI is trying to run a criminal history check and it doesn't make sense to them, they have to contact the state to clarify it. And I don't want to step too much on Robert Birding's presentation later, but in Charleston, we very quickly got into the Dylan Roof situation and what some people are trying to call the Charleston loophole as it relates to NICS checks. And I just want to explain it to y'all in case you never understood what it meant. Dylan Roof, and I'm talking about stuff that's in the public domain. This has all been reported in the media, so I'm not talking outside the Department of Justice's pending prosecution of Dylan Roof. Dylan Roof goes into Shooter's Choice in West Columbia and fills out an ATF form 4473 to purchase a Glock 45 caliber pistol. The dealer calls FBI NICS for a background check, Brady background check, and they get a delay. There's only 3 answers that the NICS can give to a dealer, and that's delay, denial, or approved, or proceed. They use the word proceed. So he doesn't get a proceed, he gets a delay. So he leaves, and they write down his cell phone number. 3 days later, you're allowed to go back into the dealer and receive your firearm, with or without a Brady background check being completed. The FBI couldn't get an answer to it, so there was no answer, so Roof was able to pick up the firearm. That's how he got it. What FBI was trying to figure out during that time was Dylan Roof's arrest at Columbiana Mall with synthetic heroin, which was, Columbiana Mall is policed by the City of Columbia Police Department, but it is in Lexington or Richland County, or both, and he was booked at the Lexington County Jail. So this Lexington County Jail fingerprint card and this City of Columbia arrest didn't make sense to FBI, and they never got to the bottom of it. And they never really concluded whether he was prohibited possessing firearms because he was a user of illegal drugs or not. So that's the Charleston loophole in a nutshell. And they're trying to figure out how they can prevent that from happening again. So throwing money at the states to modernize their criminal records system so the FBI can understand it is part of that component. That thing I just touched on may affect some of y'all with actual clients, real people that might call you for help in a situation. If they get denied on a Brady background check, they may not understand why, because they may call you and say, I've never been convicted of a felony. I've never been to General Sessions. Why am I getting denied? And one of the things I ask those people when they call the ATF office, I say, have you had a recent drug arrest? Even if it's simple possession of marijuana and you haven't even been adjudicated on it, the FBI has created their own internal rule that says you are a user of illegal drugs and you can't have a firearm for a year after that arrest. So they're going to deny you on that. And that's what Dylan Roof's denial should have been based on. Some of the media has reported that he was an admitted drug user because somebody saw that somewhere in the regulations, but all it says is unlawful user of illegal drugs. And I stuck 922G in there in your handouts. Yes, sir. From passing the background check. We could never use it in a million years for a criminal case against you as an unlawful possessor of a firearm, but FBI decided that they can use it to prohibit you from purchasing a new firearm or purchasing a firearm. They're going to deny you on that. I don't know. They just do, because they're the FBI and they do what they want. I forgot something really important that I should have done at the beginning of my presentation, is my disclaimer. The thoughts and opinions of Special Agent Mark Kelly are not necessarily the thoughts and opinions of Attorney General Loretta Lynch, the Department of Justice, or the Bureau of Alcohol, Tobacco, Firearms, and Explosives. That's very important. Yes, sir. Did you?
Those of us who are judges, we also have responsibilities as we know this. And even when we get people in front of us who have some possession of marijuana or guilty, tell them that there's a high probability for the next year you cannot have or hold a firearm because they could come out if an issue occurs or you bring attention to yourself.
It's something that ATF would never do as an enforcement thing. If we got called to go help with a search warrant and somebody in that house possessed guns and they had a pending arrest for simple possession of marijuana, we would never dream of trying to prosecute them for that. But if they had 2 prior convictions for PWID, yes, we would, because those are adjudicated convictions. So that was just something that comes up. We get that call all the time. And to finish out the NICS process a little bit, everybody who gets denied on a NICS has the right to appeal. At the gun store, at the FFL, there are brochures that they're supposed to hand you so you can contact FBI NICS directly to ask them, why did I get denied? And you can appeal your denial, because there are routine cases of misidentification. Not all criminal histories are easy to read. Somebody could conceivably have the same name as you and same date of birth as you. It may be an improper criminal history. You have the right to appeal that with FBI and try to get it so that you're not delayed or denied every time you try to go buy a gun. You can try to get it cleared up. All right, NICS check's more efficient. Okay. And in order to prove public safety, we need to do more to ensure smart and effective enforcement of our gun laws and make sure that criminals and other prohibited persons cannot get their hands on lost or stolen weapons. The administration is therefore taking the following actions: ensure smart and effective enforcement of our gun laws. In a call earlier today, the Attorney General discussed the importance of today's announcements with the nation's 93 U.S. attorneys. This is the part that, you know, it makes it look like the President has asked the United States attorneys to more aggressively go after the enforcement of the federal firearms laws. But there's a word in there, there's 2 words in there, that to me as an insider, I know the caveat, and it says smart enforcement. And this is where I get to pull down the curtain because I'm eligible for retirement. I can say almost anything I want. The public's misunderstanding of how the federal law enforcement process works. In state court, police go out and do warrantless arrests every day. It's part of their routine. They see a violation, they arrest the person. Then they write a warrant, then they get it signed by a magistrate, and then the solicitor's office has to deal with it. Every single arrest, the solicitor's office has to deal with it, or the city magistrate or the city attorney. The federal system is very, very different. ATF, in case some of you out there think you know about ATF by reading American Rifleman, that's not really how we operate. We can't go out and arbitrarily kick doors and seize your guns. We work not just for the Attorney General and the Director of ATF. We have 93 bosses. We have 93 U.S. attorneys that tell us what they want us doing and what they don't care if we do. And they have prosecutive guidelines for what kind of criminal cases they want to prosecute, and all 93 districts are different. So as ATF agents, if we want to make efficient use of our time, are we going to waste time working on cases that don't get prosecuted? Probably not. So what does smart enforcement of gun laws mean? It means the worst of the worst, and that's in here somewhere. ATF's mission statement practically is the worst of the worst. We only pay attention to multi-convicted felons that are out there doing violent things every day, like shooting and killing each other, or shooting and killing each other over drugs. So most of what ATF does is go after trigger pullers. So that's why all these other things that we talk about that put gun owners in fear of enforcement are really irrelevant. We do very, very little regulatory enforcement anymore. Occasionally, we have to get involved if guns are going to bad guys, and we have to plug it from happening. And that's why we look at the enforcement side of 922A1A, dealing in firearms without a license, is how are these criminals getting these guns? If they're getting them through people that are flipping them at flea markets, then that's what we'll do. But that was just, briefly telling you that we only work on things that are going to get prosecuted most of the time. And if we have regulatory issues, I don't mean to say that we don't work on regulatory stuff, because we do all the time. If we identify a bad apple gun dealer, as the anti-gun people like to talk about, these bad apple gun dealers, what they're really talking about is people that are really good at the business and they have a high volume of gun sales. You can't, if Palmetto State Armory is the best, if they're the new king of gun sales in South Carolina, it doesn't make them bad. It just means they're selling more guns than everybody else. So they're going to have more guns out there that trace back to them. It doesn't make them bad, doesn't mean they're breaking the law. But if we get a bad dealer, I will work with industry operations to prove up the criminal side of what we think he's done, and they'll work on the regulatory side of revoking his license. We had a dealer like that recently. I don't really want to talk about the guy, but we identified in an undercover sting in Savannah, they were ordering guns from a guy that was coming over from South Carolina, and he got them 6 guns that he used a straw purchaser to buy at a dealer, and it was such an egregious straw purchase that we felt like we had criminal proof that the dealer knew that this was a straw purchase and that he was selling it to a guy who was actually for another guy. And we were pretty sure the U.S. Attorney's Office basically declined it, so we regulatorily took his license and made him revoke his license, because there was a regulatory remedy to him. It didn't have to go criminal. So that's just kind of an example of using both sides of it. So that's what safe enforcement means. Smart enforcement. This is almost trivial. Ensure that dealers notify law enforcement about theft or losses of their guns. Well, dealers are already required to under the Gun Control Act. What was going on, this little loophole, was that common carriers were not required by law to report any theft or loss. So if FedEx lost a bunch of guns, nobody was necessarily by law telling us that they lost these guns. They were telling us out of courtesy, but this is probably the only actual regulatory rule-writing thing that got accomplished in the executive orders, is that common carriers now, if they lose some guns, the shipping FFL is required to report it to ATF. Increase mental health treatment and reporting. This is the part I hate because it muddied the waters, and I want to talk briefly about disability for being adjudicated mentally incompetent. Because what they did here is they threw together mental health treatment and mental health prohibition for firearms possession in the same paragraph. And if you read it thoroughly, it comes apart and it makes sense. But in a nutshell, they're directing money to be spent on more mental health treatment, because the mental health treatment system in the United States is broken. But on the firearms prohibitor side, we're still only talking about adjudications. We're not talking about mental health records. Mental health records are like HIPAA, non-reportable. You can't report that stuff for mental health treatment. So anybody that needs mental health treatment and goes to get mental health treatment, they should not be in fear of losing their firearms rights. In South Carolina, are there any probate court judges in here before I step on myself? All right, I'm going to skirt around this issue to the best of my knowledge. In South Carolina, a mental health adjudication is when a probate court judge says, I order you to have continuing treatment, either inpatient or outpatient, and he signs a probate court order directing that to happen. Emergency pickups are not adjudications. Emergency pickups get signed every day. And the police go and they get the guy, they commit him as he's a threat to himself or others. 3 days later, the probate judge meets with 2 attending physicians, and they decide whether he needs to have continuing treatment against his wishes, and it is so ordered. That is the mental health prohibitor. That's the adjudication that's reported to NICS now because of the Bolin Act that the General Assembly passed, the Alice Bolin Act that Leon Stavronakis sponsored from Charleston after Alice Bolin tried to shoot the teacher at Ashley Hall School. Alice Boland had multiple probate court adjudications against her that nobody knew about because the system wasn't automated. That wasn't the worst part of the Alice Boland incident. The worst part, South Carolina immediately fell on the sword and fixed that problem in a great way, made the state look good for taking responsibility for that. State of Virginia had to do the same thing after the Virginia Tech shooting. That was an unreported adjudication. The federal government, on the other side of Alice Boland, did something much more egregious. A federal district court judge pronounced her mentally incompetent to stand trial. She was adjudicated mentally competent in federal court, and it never showed up on any records. It wasn't reported through the Executive Office of the U.S. Attorney, and it wasn't reported to FBI. So that was a shame. And it was a hand of God miracle that Alice Boland didn't know how to chamber the first round in a pistol, or Dickie Schwier's wife would have been shot, the teacher. He's a city councilman in Charleston. So that's some mental health stuff. Yes, Alice Boland went to a gun store, a retail gun store in Walterboro, filled out a 4473. The dealer called Nix, and she got a proceed because none of her mental health adjudications were automated, and all of her encounters with the United States Secret Service for threatening the president and being held mentally incompetent to stand trial in the United States District Court, that was also not reported. So those loopholes have hopefully been fixed. Yes, sir. I will redefine that. Mental health care, mental health medical records are a whole separate thing. We're not talking about medical records. We're talking about courts and adjudications. In this case, probate court, where there's a real judge and a real court reporter creating documents that say you are ordered to have continuing mental health treatment against your will, and that's an adjudication. And later on in some of this gobbledygook from the executive orders, it says stuff about the Social Security. And that was bugging me until I digested it for a minute, and I realized if you're on Social Security for a mental disability, it's because you went through an adjudication process with actual judges inside of the structure of Social Security that make adjudications on your petition. And basically in Social Security, what you're asking what's the term I'm looking for? Not a regulatory judge. Administrative law judge, thank you. Somewhere in Social Security Administration, there's an administrative law judge system where you tell Social Security, I am so mentally messed up, I can't take care of myself, and I want a check from the government. So this is saying, if this person is in this category, they probably self-admitted and pled guilty to being mentally incompetent, they should not be able to purchase a firearm. So that's in these executive orders also, and I think it's hard to argue with. It's not a mental health record. It's a clerk of court record. As an ATF agent, when I read adjudicated mentally incompetent, and then somebody else in ATF legal counsel says, yeah, an administrative law judge within Social Security Administration has adjudicated this person mentally incompetent, yeah, I'd say they're prohibited from possessing, and now hopefully they'll be denied from buying. I've never thought about it until I read the executive orders. I never thought about that concept of Social Security mental disability. Somebody's collecting a check every month, and then they can go to an FFL and buy a gun? No, I don't. I think that's a good one that they address there. All right, so that's why I don't like the term treatment messed up with the law. The mental health records part of it's going to scare people, and I don't think it should. I think people should be encouraged to get mental health treatment without fear of surrendering their Second Amendment rights. And I think it's okay. It's clear. It's that the mental health records will never be reported, but they muddied it all up because they wanted to give out some money. This one also scared me a little bit because it was talking about smart gun technology. Somewhere in here it says the federal government's the largest purchaser of firearms in the United States, so why shouldn't we be pioneering and championing smart gun technology? Smart gun technology right now means a fingerprint scanner on the grip of the gun. So if you pick it up, it will only fire if your fingerprint's touching the scanner, or you're wearing a bracelet that magnetically communicates with the gun. If this administration was to run another 16 years, I wouldn't be shocked if I was carrying a smart gun. But I don't see that happening. Smart guns are a hot button issue with the gun industry because they see it as a slippery slope. If somebody perfects smart gun technology, they believe that everyone will have to sell smart guns, and regular guns, you can't sell them anymore. But the technology ain't there. I mean, when I pull out my smartphone and I have to use my thumbprint to unlock it, if I've been washing dishes and my thumb's wet, it won't work. So I don't believe the thumbprint technology is there. It's not going to be there for years. All right, we're buried down in the law. The term engaged in the business, I already did that. And there was one other thing right there that I starred. And this is where it shows up on the prohibitors: who has been adjudicated as a mental defective or has been committed to a mental institution. Those are the two words, adjudicated or committed. A commitment has to be done by a judge. A commitment can't be done involuntarily by a doctor or a medical record. So that's our law. It says who's got the mental prohibitor. Well, who's committing you? Who's committing the alcoholic? If a judge is going to do a commitment beyond an emergency pickup order in South Carolina, I can't talk about other states. I only know where I'm at here. If the raging alcoholic cannot control himself, he's a threat to himself or others, 3 days inpatient treatment, after that third day, if two physicians tell a probate judge he has to stay in here, then that's an adjudication.
What about other adjudications? Like we were talking, there was the discussion about CDD and family court adjudications around DSS requiring mental health treatment. You've got an order of the court that says you've got to go through this mental health process in order to get your kids back.
I sat through that part in Charleston, and I honestly don't know what family court does for that part.
We used to be assigned cases. Some of the resolution of those cases had an adjudication order which required the defendant to go through mental health treatment for some period of time.
I honestly don't know. It's not part of my world. I don't think we'll see it. All we know that we're reporting right now is the probate court orders. I don't know if the General Assembly said anything about family court orders. And the other thing that comes up in that debate is there's a big difference between who's prohibited from possessing firearms and who's going to get denied on Brady background check when it comes to restraining orders. Restraining orders don't mean that ATF's going to go to your house and seize all the guns you already have, because we are out of the loop. All we know is that you're going to get denied on a Brady background check if your restraining order is properly inputted into NCIC by the NCIC terminal operator at the sheriff's office, which frequently doesn't happen. It's like a worksheet that has to go from magistrate court over to like dispatch and get entered into NCIC. And there's a box on there that says NICS prohibitor, yes or no. And I can't tell you how many of them go in correctly and how many of them don't. Most of them I've seen have an expiration date on them. So a lot of these restraining orders have an expiration date built into the NCIC record, so we know if it's valid or not, just backing up to restraining orders and stuff. An ammunition question. All right, I'll try not to get too far into the weeds for some of y'all. His question was prohibited ammunition under federal law. This came up last year when ATF got goaded by the White House into re-evaluating a very popular round of .223 ammunition that has always had steel as part of its core since before the armor-piercing ammunition law got passed in the 80s. And we just kind of let it continue to be sold commercially in the United States because it didn't really meet the total definition of how much of a percentage of the projectile had to have a steel core or the other elements that are specified in the armor-piercing ammunition statute. Part of the armor-piercing ammunition statute that crept up to us on us, I can segue into one of my next slides, is it has to be chambered in a handgun. Well, what happened to us over the years that made things more difficult to enforce on that were what's a handgun? We are used to these now, but in the 1980s, these were rare, very rare. In case y'all don't know, the one on the top is an AR-15, and the one on the bottom is an AK-47. But when the manufacturers wanted to start selling these, they came to ATF with their concept, and ATF had to fit these into what's in the Gun Control Act and what's in the National Firearms Act. And what we came up with is, if this comes from the factory without a shoulder stock, it is not a weapon made from a rifle, it's a pistol. So almost every round of ammunition you can think of has now been chambered to shoot from a handgun. So they're all subject to the armor-piercing ammunition ban. So it comes down to what's in the projectile. Well, it's not a retroactive ban on possession, and it's not enforceable in possession. It's about manufacture and distribution of armor-piercing ammo. So the manufacturers don't want to get in trouble, so they basically stopped selling anything that was armor-piercing except that particular, the green tip 223, 556, it's got a steel penetrator in it. And last year, the White House wanted ATF to say those are banned. We said something about it. The internet exploded over the weekend, and the following Monday, we were like, never mind, forget about it. Just kidding. And they just dropped it because that ammunition is much too much in common distribution for us to go back and put that horse back in the barn. So you're not going to find armor-piercing ammunition in the gun store, so it's not really something you as an individual have to worry about. Well, I don't know. I'm not an expert, so I can't tell you if incendiary can be part of an explosive. You know, if you've tracers and incendiaries. Okay, there's something in that projectile that's leaving a burning trail, a tracer trail. I don't know if it can be construed as incendiary. I really don't know. I don't know if you can commercially buy tracer. Okay, well then. Well, somebody at ATF had to decide that that phosphate won't detonate. It will only leave a trail. So therefore, it's not incendiary, it's not explosive tip, so then it's commercially viable. Yeah, well, you can modify it and, you know, blow up the chamber. So the reason I threw this in here is for some of y'all, we're back to real people that might call your office about something. In South Carolina, a lawful carry is in the glove box or compartment of your motor vehicle, which has a two-step latch process. Can you fit this in a glove box in your car? Maybe not. Should you have any business trying to carry this thing concealed or put it in your car for lawful carry? Probably not. So what's the purpose of it? You can't carry it in a holster. You can't carry it in your gun just because it looks cool. So you have to carry it in the trunk of your car. So if an officer pulls you over and this thing's laying on the floor or the seat of your car because you can't get it in the glove box, that's going to be a misdemeanor on lawful carry. So these things, the cops don't even know about this stuff until they experience it. And AR-15s make stupid-looking pistols because of the buffer spring tube that you have to put on there to house the bolt spring, and they just AK-47s make cooler-looking pistols.
Quick question: if you put a folding stock on that AK, would it classify as a handgun?
If you put, as an individual, if you buy this and then you put a stock on it, you have manufactured a short-barrel rifle under the National Firearms Act. So don't do that. There's a lot of tricky NFA questions. The more guys that are out there trying to fit things into the niche market on cool guns, you can also cause other people to have a problem. Not that we would ever prosecute you as a non-convicted felon, an otherwise non-prohibited person for having a short barrel rifle. We probably wouldn't, but we might seize it and destroy it, and you'd be out $1,000. So you don't want that to happen. Anything that you see with a folding shoulder stock is going to have a overall length of greater than 26 inches and a barrel length of greater than 16 inches so that it is not a short barrel rifle under the NFA. It's merely just going to be a rifle with a folding shoulder stock. So if these have short barrels that are shorter than 16 inches, then you can get in a problem with a short barrel rifle. you're talking about the SIG arm brace. A couple years ago, those AR-15 pistols got really popular, and the story goes that there was an inventor that was trying to help a disabled vet who lost his left arm, and he wanted to shoot his AR pistol, and he was having trouble holding it because he had nothing to grab the forend with. So he came up with this Velcro plastic thing that's strapped onto his forearm, and it's commonly referred to now as the SIG arm brace. And you can strap this Velcro on your forearm and control the firearm better. So ATF approved the sale of that because we said it's not a shoulder stock. It's clearly not something that's intended to make the firearm to be fired from the shoulder. So we issued that ruling on the SIG arm brace and said they're legal. Well, then what happens behind the background at FTB, Firearms Technology Branch, where they make all these rulings, is they get flooded with designs from other inventors that want to make other similar stocks, or similar, they're not stocks, they're braces. And they were getting longer and longer. So you're going to take an AR-15 pistol and then put a shoulder stock on it. So some of those designs got turned down. So then we had to issue this ruling defining that if you take a SIG arm brace and you shoulder it, as an individual, you are at that moment creating a short barrel rifle. And it sounds stupid, but we were driven to do it by these other inventors that wanted to have another kind of brace that was turning into a shoulder stock. And we can't rewrite the National Firearms Act of 1934. We have to work within what it says. And within what it says is designing intended to be fired from the shoulder. And that's where they're at with that. So that's the story of the SIG arm brace. This one I just saw recently. Apparently this was in a Terminator movie, and all of a sudden these are popular now. And there's a special category of shotguns that doesn't make sense to most people. Briefly, a pistol grip shotgun, if it comes from the factory without a shoulder stock, but it's greater than 26 inches in length, which is the concealability measurement of the National Firearms Act, and has a barrel length of greater than 18 inches, ATF was forced to put it into a category, and so we just call it a firearm because they didn't fit into the shotgun category, but it's treated like a regular GCA firearm. It's just like buying a shotgun. We don't technically call them shotguns. But there's plenty of Remingtons and Mossbergs out there that have pistol grips, and there's no way we can prove that it came from the factory with a pistol grip or a shoulder stock. Same thing for this. This is commonly called a mare's leg because it showed up in a TV show and a movie with Westerns, late 1880s. Several manufacturers decided that there would be a market for these. So these come from the factory with what is not a shoulder stock. It's not designed and intended to be fired from the shoulder, so we treat them like a pistol because it has a rifled barrel. So that is also a pistol. So these are some of the other hoops that ATF has to jump through all the time to work with the industry to categorize things that the industry wants to sell and tell them yes or no. We agree or we disagree with your interpretation of it. Now, I mentioned earlier when I was talking about dealing in firearms without a license, what time is it? I have no idea what time it is, Steve. Am I good? Oh, that's right. I had not my representatives. Jenny Horn wasn't here. I live in Somerville, so this is how you take the criminal side, the criminal intent side of dealing in firearms without a license, and you apply it in an enforcement action. National Guard soldiers pleaded guilty to firearms charges in federal court today, admitting they illegally sold numerous guns, including military-style assault rifles and ammunition, believed that they were heading for Mexico. So what happened with this? You guys are in the Army. They're not convicted felons, but they're like stealing and selling military firearms, NFA weapons, which didn't wind up in the indictment. But as they were, this word was out about this, maybe an informant knew about it, contacts ATF, they introduce an ATF undercover agent to these guys. And this ATF agent lays out the language that creates this illegal act. Rather than just dealing in firearms without a license, he says, I need guns to take to Mexico because I work for the cartel. And they say, okay, we can get you guns. So they start going to gun stores and they buy guns and they resell them to this guy for a criminal purpose. So that's how easy it is for us to turn an unlawful dealing in firearms innocent act into a criminal act. It's just the introduction of some conversation. And we do it all the time. We did it in Charleston at the Ladson Fairground flea market several years ago. We had ICE arrested an illegal alien from Brazil. not because he was a legal alien, because he was consigning a shipment of household goods to Brazil that happened to contain about 20 firearms, which is smuggling, it's illegal exportation. So they start talking to this guy, and he starts cooperating. And they're like, "Where'd you get these guns? You can't go to a gun store and buy them. You're a legal alien." He says, "Well, you go to the flea market. You go to the Ladson Fairgrounds, and there's guys there with tables selling guns." So we start going to the Ladson Fairgrounds and talking to the guys that are selling guns without a license and saying things like, I can't go to a gun store and buy a gun because I'm a felon. I've been to prison. So then they're knowingly then selling us guns as felons. They know we're felons. And then we start placing orders. And we say, "Well, look, I really want a Glock 45, and you don't have one. Can you get one for me?" "Oh, yeah, come back next Saturday morning. I'll have one for you." So they're taking orders, they're engaged in the business, and they're engaged in a criminal act, knowingly transferring a firearm to a convicted felon. So that's how we make those cases out of that statute. I suppose it could be a defense, but I think as you continue to engage this guy in conversation, he clearly is getting into it for the money. I don't know how many juries wouldn't go along with that. It's like, you got him, and he's going along for the ride all the way. He could say, "Well, I didn't really think he was a felon." Well, I can't tell exactly why it works, it's just that it does. The Fourth Circuit says it does. The Fourth Circuit has upheld cases from North Carolina with as little as 4 firearms in them, and that's in the executive order speech because of the verbiage, the things that ATF said to the bad guy. He said, I can't get a gun, and I have to go whack this guy. He's pissing me off. I need to shoot him in the freaking head. I need a gun. And the guy sells him a gun or gets him a gun and delivers it to him. And he says, that went well, and I had to throw that one in the river. Can I have 2 more? And we do a second delivery. We only got 3 guns, but Fourth Circuit has upheld that as dealing in firearms without a license with criminal intent. So it works. That's how that law works to protect your Second Amendment rights and give me enforcement power on dealing in firearms without a license. I think that's all I had, Steve, unless you want them to ask one more question. I didn't want to run into the next presenter.
If you're going and buying a pretty large volume of guns, FFL does a raid background check, is there something that flags you in the system that says, this person bought 20 guns?
Large number of firearms, does it flag you in the system? I'll give you the quick answer. If you buy long guns, nothing happens unless you're on the southwest border states. Congress threw us a bone in about 1972 and said if an individual buys 2 or more handguns in a 5-day period, that might mean something to law enforcement. So the dealer is required to do a multiple sale form report to ATF. So if you're out repetitively purchasing a large amount of handguns, yes, I see that. That's the only database that exists, multiple purchases of handguns. And it helps us on interstate gun trafficking. If a guy comes down here from New York and he recruits some local people to go buy multiple handguns for him, and I see a bunch of 21-year-old females going out and buying 3, 4, 5 high points or Jimenez pistols at the same time, I know something's up. So it's the only proactive thing we have. But as far as an individual buying, going and buying 2 AR-15s and 3 shotguns and, something that's not a handgun, we'll never know it. Unless you're on the southwest border. It was something that came out of, I don't want to call it an executive order. It's a demand letter. ATF has a regulatory authority to tell dealers to do certain things. So demand letter number 3 was telling the dealers on the southwest border that you have to report the multiple purchase of rifles greater than .22 caliber to try to get a handle on how many AK-47s and AR-15s the cartels were buying on the southwest border so we could get a heads up. And I don't want to say fast and furious because that was the worst thing that ever happened to ATF, but this is a totally different enforcement initiative that is actually working. And I'll be around for a few minutes out back, but I'm going to leave by 4 o'clock.